where is the political ombudsman in all of this? When you have expletives being thrown around, words like war being thrown around, you don't get that public condemnation from the office of the political ombudsman. And I think that's a cause for concern, and certainly reason enough for us to say we need back a standalone political ombudsman. Beyond that, if you remember, Member of Parliament in Portland, Daryl Vaz, made some comments recently on the stage that drew the condemnation of Equality for All Foundation, JFJ, Stand Up for Jamaica, and the church group, I believe, Jamaica Council of Churches also spoke. And we wrote to the Office of the Political Ombudsman. I believe it was towards the end of June, Jade. And we got a response acknowledging receipt 3 weeks after, just to say that we acknowledge receipt of your letter. And I asked myself, how long would it take for an investigation to happen when this is just a public statement? So this is not 3 weeks after and you're getting something a little bit more substantive to say, listen, we've heard the utterances, we've written to the MP, or we don't find that it's in contravention to the code of ethics, the code of conduct, my apologies. Nothing, just to say I acknowledge receipt of your letter, the correspondence. So again, I think we have to look at how effective the ombudsman is as it stands now, and again revisit it being a standalone. To move on to some other things very quickly in terms of the week that was, the Prime Minister, as you know, is the chair of CARICOM.
Yes.
And he made some very important comments yesterday as he welcomed the other heads of government. For example, that regional approach to crime fighting, dismantling the gangs. And I think that's very important because security is one of those underpinnings. If you remember what the CSME and CARICOM we've signed on to. So I think that is something I join the Prime Minister, that we need a stronger approach, unity in how we approach security matters across the region, you know, witness protection matters and how people may find refuge across the other Caribbean islands. So that's something I do support the Prime Minister wholeheartedly, personally and on behalf of JFJ with. We also, you know, there are so many things last week, Jade, so I have to move quickly. We saw Winston Anderson, Justice Winston Anderson being sworn in as the president of the Caribbean Court of Justice. We thank the former Adrian Saunders, who served remarkably well. But Justice Anderson is a man of Jamaican soil from St. Anne, I believe the Garden Parish that I also hail from. So I have to plug that there. So, you know, we congratulate him and we look forward to his work that he will do quite well, I'm sure, based on his background and the number of years that he served in other similar capacities. But certainly, we also join the call that Jamaica and other Caribbean islands need to move with signing on to the CCJ as its final appellate court. All right. There are some other things that we will touch on towards the end of the program, because I do have something to say around the access to information request that the RGR group submitted to the Office of the Services Commission regarding the FID terms of reference. Because when it comes to ATI and our right to know and good governance and transparency, how that was approached, I think is a matter of concern. So we will touch on that very briefly towards the end of the program. All right?
All right. Thank you for that, Mikhail. So we're going to go into our right of the day and our trivia question for today. So our right of the day today comes from the Constitution, I'm fairly certain. Okay, yes. So our right of the day today speaks to seeking redress. So under Section 19 of your Constitution, your Charter of Rights, it gives us the power as ordinary citizens to seek redress if the Constitution or constitutional rights are violated, right? And this is individuals, authorized organizations, etc. And the Supreme Court has the power to hear these applications, issue orders, and enforce the rights. And it can also refer the cases to other courts or bodies. And why it can do that is because in our system, if there is another remedy, another process that is available, then the court will usually direct you to that process before it tries to hear it on a constitutional matter, right? But you do have that right to seek redress. We also have a trivia question for today. Our trivia question today is, which section of the Constitution details your right to due process? So there is a general part that says you have a right to due process. That's not the part I'm looking for. I'm looking for the part that details what that right to due process means. So you can respond to that by responding on our Instagram, JA4Justice. You can respond on the YouTube chat, or you can send a WhatsApp to 2397583.
All right.
Yes.
Is Bethany on?
Yes, she is.
Okay, Jade, I can't see a thing. I don't mind saying that publicly. So if you could lead on starting the topic.
Most certainly. All right. So the sentencing in the Mario Deane case was delivered on the 1st of July 2025 in the Westmoreland Circuit Court. 3 police officers, Corporal Elaine Stewart, District Constable Marlon Grant, and District Constable Juliana Clavon, were sentenced for their roles in the 2014 death of Mario, who was 31 at the time of his death. Now, the court issued the following sentences for Corporal Elaine Stewart: 5 years for manslaughter, 1 year for misconduct in a public office, and 1 year for perverting the course of justice. These sentences are to run concurrently, which means at the same time, and she was granted bail pending her appeal. District Constables Marlon Grant and Juliana Clavon received 3 years for manslaughter and 1 year for misconduct in public office. The manslaughter sentence was suspended for 3 years, and the misconduct sentence was suspended for 2 years. So this means these sentences will not be served in prison. However, if they commit any offenses during the suspended period, then they would be incarcerated subsequently.
All right. So the sentencing outcome, understandably so, drew disappointment from the public, anger in some respect, and, almost a defeatist mode.
Yes.
In others, wherein, unsurprisingly, the justice system has failed again. That is a sentiment that I've seen when I personally look through some of the social media comments and so on. We've spoken to Ms. Fraser, and I'll ask Bethany to share a little bit in terms of Ms. Fraser's reaction immediately following the sentencing. But from us here at JFJ, our reaction, as we indicated in our press release, it was mixed. Because when you look at the sentencing outcome for Stewart, arguably, or from our perspective rather, it was a good judicial response. And I'm going to explain, Jade and I, in a few, why we think that. And for the other two, we were disappointed with the suspended sentence. But I also want to be careful as I speak, you and I, Jade, around why we were disappointed.
Yes.
Because I think we have to manage our public statement in expressing our disappointment. Because one of the things we have to do as an organization is ensure that our public statements are principled and not because of who is involved.
Yeah.
And we also have to balance, because most of your attorneys, you, our board chair,
yes,
and we have to be balanced with our understanding of the law, but our positions as advocates. Mm-hmm. When we don't put on the advocate's hat, rather, and we forget what the law is and the reasoning behind the law,
yes,
to the point where we start speaking legalese, wherein it's almost like we're not fulfilling our obligation to our clients. Mm-hmm. So it's a balance that JFJ had to ensure that, it was struck as we spoke. And if you read our press statement on our social media platform, you would recognize that we went through great pains to explain the matter of sentencing, the sentencing guidelines, We explained the matter of suspended sentence to say that if they slip the slide during that 3-year period, so in other words, if they commit another offense, they may very well find themselves, serving out the prison term. So we went through great pains to explain all of that. But I also want us to hear from Bethany Parchment so we can understand some of the factors that the judge considered as he issued that sentencing for all three. The mitigating factors, the aggravating factors. So we're going to take the break, and then I will ask Jay to explain what mitigating factors are, what aggravating factors are, and then we hear from Bethany Parchment in terms of what exactly the judge considered as he handed down those sentences.
Yes.
When you want the food and make the rice well, just give me Kendall. Kendel. Give me Kendall.
Another quality product from the CariMed Group.
Just give me Kendall.
The time by Kendall Foods. The taste of quality is
1:16.
Back to school doesn't have to break the bank. Swap instead of shop. Join Nationwide 90 FM at our Back to School Fair on Saturday, July 26 from 10 a.m. to 6 p.m. at Harmony Beach Park in the western city of Montego Bay. Bring those books your kids no longer need and swap them for ones they do. Plus, enjoy fun activities, entertainment, and meet your favorite Nationwide personalities. It's all happening in St. James on Saturday, July 26 from 10 a.m. to 6 p.m. at Harmony Beach Park. See you there.
Welcome back to Let's Start Justice. We are discussing the ruling in the Mario Deane matter. We are joined by JFJ's intake officer, Bethany Parchment, who was also attending the matter on behalf of JFJ. Mm-hmm. But before we
don't reach aggravated factors yet, actually. We should have explained the issue of manslaughter.
Okay.
Voluntary versus involuntary. I'm not sure if you remember the differences quickly.
Oh boy. this is like my criminal law class.
Yeah. So voluntary manslaughter, there was some intention behind the killing.
Yes.
But there was a strong mitigating factor. For example, provocation, wherein you would not have been charged for murder. Mm-hmm. So for example, in the United Kingdom, if you are charged for murder, you know that you may it's life imprisonment. Mm-hmm. You may serve a whole life sentence. But if, for example, you were provoked, and I don't mean provoked because somebody just make you angry, provocation to the extent where anybody else in your situation would act in a similar vein, then you could be charged instead for voluntary manslaughter. In other words, you will end up serving a lesser time. Then you have involuntary manslaughter. Now, you want to take that one?
Yes, sure. So involuntary manslaughter is when there is no intention, right? But there was a death that occurred, and there was a level of responsibility or duty of care that you had to the person who is now deceased.
Like in reckless driving.
Yes.
You didn't intend to kill anybody, but you wake up, you go party, you drink a whole heap of alcohol, and therefore it resulted in a death. And I think it's important for us to understand the distinction as we have the conversation. So in this particular case here, the officers were charged for gross negligence manslaughter. What exactly does that mean? Remember that there is a duty of care for the officers because you are in the custody of the state. And in these situations, a statutory duty of care as well as a contractual duty of care.
Yes.
So you are obligated to act in a manner that will ensure that there is security and safety of the officers who are within your care. So I see a comment here on YouTube, for example, how can you hear somebody screaming for help and you don't do anything? Those were some of the things that would have led to gross negligence manslaughter. What was the duty of care? Was that duty of care breached based on the facts of a particular case? And did that breach of duty result in the death of an individual, in this case, Mario Deane? And when you establish all of those factors, then it would have determined the charge, which charge was made, and then those things would have influenced the decision or the outcome that the jury made in this particular case, which led to a conviction. Yes, there was a duty of care. Throughout the trial, you heard about some book of rules and so on.
Right.
You heard about who was on duty, what was the level of responsibility, was that breached, and again, what is the contributing factor towards the death. And at one point, you heard the defense talking about whether or not the hospital, if they had acted in a quicker manner, then maybe Mario would still be alive. So in other words, they were trying to shift the duty and the negligence perhaps to the hospital at one point. So those were some of the elements that went in. So it was important for us to make that distinction for the listeners, because I think we perhaps equated, or it wasn't properly explained to the public, that the officers weren't directly responsible for the death as you would be thinking about a murder charge. They didn't kill anybody, right? But because there was a breach of their duty, it resulted in Mario's death. And therefore, at no point you would be hearing 40 years imprisonment and so on.
Right.
So I think it was important for us to explain that to the listeners, and perhaps we should have before, because maybe that would have helped with some of the expectation in terms of the sentencing outcome.
Sure.
But yeah.
Okay. Right. So just before I ask Bethany the question, to say that as we talk about sentencing, a mitigating factor as it relates to sentencing is actions that the person who has been found guilty, the convict, actions that the convict has taken to reduce the level of harm that is associated with the offense, versus an aggravating factor, which were actions that increased the level of harm. So say, for example, we're talking about a case involving sexual assault. If there was a firearm involved in that assault, then they would consider that to be an aggravating factor when they're doing sentencing. But maybe, say in that same case, the person who committed the offense, this is their first offense and they are a minor, those would be considered mitigating factors in those circumstances. So Bethany, are you with us?
Hi, yes, I'm here.
Thank you
So
for
that's
joining
Bethany
us.
Parchment, our intake officer. So if you call JFG and you make a complaint, you'll be hearing her nice soothing voice, walking you through the process and so on. All right, so welcome, Bethany.
Hi, good afternoon. Thanks for having me. And good afternoon to your listeners as well.
Our listeners.
All right, Bethany. So, I think you can kind of bring us through, as the court was going through its deliberation and its reasonings, what were some of the major factors that the court considered? I don't know if you want to do it per defendant.
We can start with Stuart.
With Stuart,
And
sure.
then we just deal with the other two officers together.
Okay, well, for Corporal Stewart, the starting point for manslaughter for her was 7 years. He had to consider for each defendant the culpability in the offense committed, right?
Sorry to pause again, Bethany. I just want to ensure that the public understands again what we mean by starting point. So the usual sentencing range for manslaughter based on the sentencing guideline for the Supreme Court is 3 years to 15 years. When we look at case law, which is similar matters that were heard in the United Kingdom, for example, for gross negligence manslaughter, my own reading of some of those cases, the sentencing usually imposed is 10 to 12 years. So the prosecutors had recommended that the court started at a higher range of the usual 3 to 15 years by recommending the starting point of 10 years. And the judge opted to start at 7, which is a mid-range. All right? Go ahead, Bethany. I just wanted to explain some of the language.
Okay, yeah, man, no problem. So yes, he had to look at the culpability of each offender. And for Corporal Stewart, she bore majority of the responsibility because, of course, she was the sub-officer in charge. unlike Grant and Clevon, who are only district constables taking orders. So the starting point was 7 years, and the aggravating factors that he would have looked at would have included the abuse of power. And that was interesting because he did note that she would have abused her power by taking his statements, his utterances while being in custody personal, and that leads to the other aggravating factor, which would have been the breach of the right of the person, because Mario Deane was put into a cell for an offense of being caught with a spliff, right?
It was $100 at the time, if a fine had been imposed. And the comment was that he doesn't like police.
Yeah, and they noted that instead of placing him in a cell while waiting on his short to arrive on bail, they should have placed him in a more secure area. Anywhere else would have been fine. In the reception area, it would have been okay, rather than endangering him and putting him back into a cell. And as the witness Julian Williams would have testified, the persons in that cell were of unsound mind, right? So the mitigating factors that he looked at for Stewart would have been the fact that there were no previous convictions. She had a good conduct in taking care of prisoners, and he also noted that Julian Williams, in his evidence, he testified to the fact that she performed her duties in ensuring that the well-being of the prisoners were being taken care of. He also looked at the fact that they had a good background, a good family background, and a good education, and they were with good standing within their community. All 3 accused social inquiries were done on them, and the reports produced that, the community was ready to accept them back. They had no trouble with the law, no issues with any other prisoners in the past. So these were things that the judge had to consider, and for each mitigating factor, he would have decreased a year off of their sentence. And that is how we ended up with 5 years for manslaughter for Stewart. And then she was given an additional year for the tending and doing acts to intend
perverting the course of
justice, and for the misconduct in public office. And for Grant and Clevon, he both started them off at 5 years for manslaughter. And then for the aggravating factors for both of them, he had to look at the fact that they failed to provide safety for Mario Deane. Because in their testimony, they said that Clevon and Grant, they were the ones who put Mario into cell 4 because they were trying to ensure that he was safe due to threats from the prisoners who were in the original cell that he was in. So when you looked at the aggravating factors, he had to subtract a year off from their sentence.
Mitigating factors.
Pardon me?
When you look at the mitigating factors, you said to subtract.
No, for the aggravating factors, you would have to subtract a year off of their sentence. But add a year to their sentence.
Okay.
Sorry.
All right.
And then for the mitigating factors, that's when he would have done the subtraction. And the mitigating factors for both Clevon and Grant were the same as Stewart. No previous convictions, good conduct in taking care of prisoners, good family background and educational background, and good standing within their community. And then they ended up as 3 years for manslaughter. And of course, they had that additional year for misconduct in public office. It is noteworthy, however, that the judge ordered an additional 1-year sentence for each accused for general deterrence. His hope or his aim is that this would act as a deterrent for other police officers to know that, hey, if they do neglect their duty of care, then they can be found and held accountable by the state.
Yes.
He did, one thing that really did sway his opinion in sentencing is the fact that in the social inquiries and also through the character witnesses for each accused, it did say that this behavior, this was out of character for each of them. They're hardworking, industrious persons, and the community was ready to accept them back. So the fact that there was a low rate of recidivism and the fact that they did not pose a threat to the general public, those were huge factors in considering their sentences.
Well, I think my consideration would be whether or not they pose threat to future inmates, but yes, we acknowledge the reasoning there. Just quickly before we go to the break, what was Miss Fraser's reaction, Bethany, once these sentences were read in court?
He was very disappointed, very disappointed. I may even say annoyed even. It was just a very anticlimactic thing because we're all coming off of the high from the guilty verdict. And so, of course, we're hoping and looking forward to something that can match that feeling of, So, the air was disappointment, not only by Miss Fraser, but her sister as well that was there, Andrea.
Hold that thought for me, Bethany. We're going to take the break and then we wrap up with another 2 or so minutes with you. All right?
Okay.
At the Jamaica Customs Agency, we care for our employees, customers, stakeholders, citizens, and our country. Customs cares. The temperature by the Jamaica Customs Agency is
30 degrees Celsius here in Kingston and 31 out west in Montego Bay.
Are you looking to drive sales and build brand visibility this summer? Be a vendor at the nationwide 90 FM Back to School Fair on Saturday, July 26th at Harmony Beach Park, Montego Bay. Families from St. James, Hanover, Westmoreland, Trelawney, and St. Elizabeth will be out in full force. And you should be too. Call us at 876-630-1210 or email sales@nationwidenewsnetwork.com to secure your spot. Let's put your brand where it matters, on the ground.
All right, welcome back to Let's Start Justice. We're discussing the matter of sentencing that we saw in the Mario Deane case, and we are trying our very best to, in articulating our own disappointment here at JFJ, to also manage some of the expectations and to properly explain the factors that went in, the issue of manslaughter and why you wouldn't find a significantly higher sentencing for the officers involved, because we have to look at the particular act here, because remember 3 others were found guilty who did the killing versus duty of care and how you factor all of that to come. Similarly, if you go to the hospital and you're not treated well, medical negligence can result in death. But you wouldn't find the doctor serving a 30-40 year sentencing. He would be serving, again, based on the usual time that we saw in other cases, between 10 to 12 years, imprisonment. And I think that's important. So before the break, we were asking Bethany just to indicate what the mood of the court, those who attended court, was. And she articulated that Miss Fraser was disappointed. There is this anticlimactic, feeling that you're coming off the high of the conviction to hear, oh, no prison term, So, Bethany, you can continue, please.
Well, yes, as I said, the mood in the court, it was, I think the word that really encapsulated, I can't really find any other, is disappointment. While the judge noted that he was hoping that it would deter, future officers from, committing any acts of a similar nature, I think it partially served its purpose, because it would have hit home harder if we actually saw all 3 officers going to prison. It also would have acted as a greater deterrent, to know that, hey, not only can you be found guilty, but you actually will serve a prison sentence. I should also note that the judge stated he was trying to explore other options because with the crime of manslaughter, persons may be asked to pay a fine instead of serving a custodial sentence. But he did mention that given the legislative history, while acknowledging the Indicom Act and also underscoring JFJ's role in advocating for the establishment of Indicom, he said that given the legislative history, there has to be a custodial sentence for a crime like this. So
Yeah.
at least Corporal Stewart would be facing some prison time for, given the fact that she was in charge.
Yes. All right. Thank you, Bethany. Really appreciate your joining. Hopefully next time you'll be in studio with us.
Yes, looking forward to it. Thanks for having me.
I hope that's not just one of those comments people just make. What you mean? It's all right. Thanks so much. See you in the office.
Okay.
And one of the things, for those who watched All Angles, where our board chair and DPP, Paula Llewellyn, were on, you heard her saying that, listen, the sentence may be lenient, but it was not unduly lenient to the extent where her office would appeal. And we agree.
Yes.
Though we are disappointed, we agree with her assessment that it was lenient, which is why we're disappointed, but it's not unduly lenient where we would be calling on the DPP to appeal. Because again, the usual time frame was actually adhered to. But when we looked at the issue of duty of care, in our humble opinion, and we said we respectfully disagree with the court, that couple of months, a year, something,
Yes.
should have been. So where do we go from here, Jade?
Well,
Because people said it mean nothing, was just the survey. You see the comments in YouTube.
I think that we can't ignore the significance of securing a conviction of this nature. I think that
Because I personally, listen, I went on that, what you call this site that we always talk about?
LexisNexis
Or something like that. And you look at all of the case law, and I couldn't find anything for gross negligence manslaughter in Jamaica.
Yes.
And when I look in the Commonwealth, UK and so on, it's really medical negligence I was finding.
Yes.
Nothing speaking to police custody and duty of care in that remit. So, historic conviction.
Yes, it is, and I think it is persuasive going forward. As much as we look at sentencing as a deterrent, I think we can also consider the conviction as a deterrent. I'm sure that many a police officer would never want to be convicted, regardless of whatever sentence comes out of it. And once you secure that conviction, your career is over as a police officer.
Because you can't be reinstated because
No.
you have a conviction, though you're not serving the time in prison. You have a conviction.
Exactly.
But is that guaranteed, Jade, or is it left up to the discretion of the administrative function of the JCF?
Well, as far as I'm aware, it would be an administrative matter because it is a policy decision.
So the next step for JFJ, I think we need to write and find out.
Yes.
Because that's important for the public. And this is why, it's important for us to make complaints to iProbe and Indicom. Because once you have a complaint against you and anything were to happen, the court would have access to prior acts, bad acts. These so many allegations against this one officer. I want to go on with you, sir. So I want to encourage the public to make your complaints to iProbe. Make them to Indicom. Call JFJ. We will walk you through the process if you're not aware. But make your complaints so you can make them to JFJ too, because we have also signed over documents to the courts to aid in certain processes, legal proceedings.
Yes.
So make your complaints, very important. All right, we have to move on because we do have a pre-recorded interview. But I think very last point here, time has arrived for us to reform the state of lockup and prison. And there is a letter next week on our show, Jade, I will read, because we got a well-written letter from some inmates at prison that I think we need to read to the public as we advocate for prison reform. All right?
All right.
So over to you to introduce the pre-recorded interview.
Okay, so we did see on January 17th, 2024, a ruling from the Supreme Court which was affirming Section 7.2 of the Integrity Commission Act, well, affirming the point that it imposes a legal obligation on individuals and entities to cooperate with the Integrity Commission by complying with its information requests. Now, the matter came out of a request for information with 151 public officials to the investment company Barita. The request was refused by Barita, which they cited the possibility of violating our constitutional right to privacy, as it was articulated in the matter Julian Robinson and the Attorney General. Now, Justice Stamp in the matter distinguishes this matter, that is the Integrity Commission matter, from that of the Julian Robinson case, as it did not involve the initial collection of data, simply the verification of the information already disclosed. And the judge went further to say that by submitting statutory declarations, public officials have given implicit consent to the verification of that information, and that, quote unquote, corrupt practices and enterprise are typically concealed, necessitating robust mechanisms for detection and enforcement. So we spoke with data privacy expert Chuck Cameron, an attorney at law. So we'll take the first clip.
The overall challenge I have is the floodgates that it has opened up for the state to overreach and further restrict our right to privacy in a tangible way. So that's a general thing, because here it is, you have an investigative commission not conducting an investigation, but accessing persons' personal data outside of the mechanisms, the protective mechanisms and the tools that are afforded them in the Integrity Commission Act. So that is a big picture problem that I have, that the rights of Jamaican citizens are being stripped for no lawful, or it's not necessary in any way, because at no time is the Integrity Commission hamstrung or in any way prevented or restricted from doing robust investigations. In the normal course of things, what would happen is that they would go to court in furtherance of an investigation and apply for the court to issue a notice to produce.
Yes, so that was in response to my question to him at that time was, what were the major challenges that he identified with the judgment in relation to data privacy, as he's an expert on the matter.
Yeah, let's take the full clip before I give commentary, because I'm siding with Attorney Cameron in many respects here.
Well, the second clip speaks to the effect of the judgment. I don't know if you want to comment on that point or you want to hear.
No, I'll hear. But just to say to the public, Integrity Commission, you're an anti-corruption agency. That's the purpose of the act. But we also have a beautiful constitutional right to privacy, informational privacy, so brilliantly outlined in that Julian Robinson matter, which the court made reference to.
Right.
But as we fight corruption, how do we balance?
Right.
Yeah.
Okay.
So take the next clip and then we'll have a quick discussion.
All right.
What is the effect essentially on an ordinary citizen? Is this something that only concerns public officials and those closely related to them? Is this something that the average person needs to be concerned about in terms of what it means for their privacy rights?
Every Jamaican citizen now has to be concerned. First, because it affects everyone. Why? So if we were to speak in a lofty manner, we would say that politicians would be less likely to want to serve publicly if there is no protection.
Mm-hmm.
And so we must follow the rule of law, so they know what their exposure is and they don't unnecessarily expose their family members to prying eyes unnecessarily. If it is the law says, yeah man, you are a human, your rights are respected, and if anybody is going to pry into your business, they have to go through the court, and you're protected. And no individual can arbitrarily, outside of conducting an investigation, access all the information. One could argue that, but what does that have to do with the man on the road? The average man on the road is not trying to be a politician. The average man on the road is of the view that, yeah man, if you serve in public office, you have to show everything. So what is GFJ talking about? What is Cameron talking about? They are in support of corruption and they are promoting corrupt politicians. GFJ, you disappoint me because you are supporting a corrupt politician. So that is one thing you could argue. However, it touches us personally. Because now, when the Integrity Commission asks, how many children does that politician have? Because that is a standard question the Integrity Commission has asked, not is likely to ask or may ask, has asked. Because the thinking is, you may hide your wealth behind child offspring. So you put all the things you own in the name of your children. So when you're receiving an unsolicited or illicit gift, you don't accept it directly. You just accept it and put it in the name of your child. That's how the thing works. And that is what they are trying to prevent against. So it is for that reason they would ask the question, how many children do you have? So they know the scope of their investigation. That's real. So what the Integrity Commission did in this case, they said, we're not investigating the over 100 public officials. They're just verifying the information. So now, what it means is that they can suspect that you are the baby has mothered a child for a politician. They can go to any hospital and say that we would like to verify the number of children this public servant has. But we believe, and we have reason to believe, that you have mothered a child for this public servant. I need your records. I need your medical health records. I need all the records from your bio. That every time you went to biomedical lab, I need those records. That sounds far-fetched, doesn't it?
Yes.
But let's break it down. Why is it far-fetched? What happened in this case? The only thing that happened in this case, is that public officials were compelled to file their statutory declarations. They didn't suspect the 100 and odd people of any corruption. They just wanted to verify the information on the statutory declaration. So if it is, you have to declare who your children are. Why is it unreasonable to think that they're not going to verify that information? So the same way they go to the bank to verify the financial record, why would they not go to a medical health provider to verify how many children you have?
Some things there for food for thought, but is this opening up the floodgate to verify any and all information that you have shared and the implications for families of public officials? But let's take the final clip and then, Jade, we have a quick discussion.
Okay, so this final clip, I can't remember if the question is in it, so I'll just say that I asked, the judgment spoke to the consent being implicit because you are a public official and you submit declarations. You knew that was a thing you had to do, and so you have implicitly consented to the verification.
And it's not really a breach because it's simply verifying
right.
information
So you
that you had already submitted.
Right, you didn't engage the right. So we'll take the clip now.
And the court seems to be of the view that, yeah, it is a verification. And that is why it is so manifestly different than other challenges that we've had related to data privacy in Jamaica, that they're verifying simply information that you've already disclosed. And so it essentially, you have, what should I even say? You have mitigated, given up somehow that right to privacy, that you have not engaged it in the way that the Constitution envisions. How do you respond to that?
So what the court did, you are correct. What the court said, and I said you are correct. I didn't say the court was correct. What you said is correct, in that because the public official put out the information in the statutory declaration, there was implied consent for the third party barrister to disclose that information. That is what the court said. Let us break that down. So what is consent? From a layperson point of view, isn't consent when you voluntarily agree to something? Last week, was it last? Well, I'm sure you have spoken about rape. We're speaking about domestic. Well, I was on the show.
So we spoke about data privacy and domestic violence 2 weeks ago.
We're speaking about domestic violence. But think about the whole concept of rape. Consent means you say, yes, I voluntarily want to have sex with you. But if it is, if you don't have sex with the person, you are going to be shot or you are going to be punished. Can that be considered to be consent?
By all I know.
When the law says if you don't file your statutory declarations, it's a criminal offense for which you will be prosecuted, for which public officials have been already prosecuted. How can that be implied consent? If it is you don't file the statutory declarations, you will be punished. That is not consent by any stretch of the imagination. That's one point. The second point is, under the Data Protection Act, that allows data controllers to infringe upon persons' privacy. And that is what happened in this case. You're going into their private bank account, so you are restricting and infringing upon their privacy. The law does say that if you have their consent, you can do so. However, that consent must be explicit and unequivocal. There is no implied consent, because you can't give up your right, your constitutional right, by implication, because it looked like you did want to agree. Constitutional rights and law does not work in that manner. The third point is, if it is we accept the thinking of the courts, where I gave up I consented to have for this to be conducted, or my information to be processed in this manner. I gave my consent to Integrity Commission to use my data. I did not give my consent to Barita to disclose my information to anyone. So the consent that the Integrity Commission may have is not extended to any third party. Before they can release my private information, they have to have my consent or some other lawful basis to do it. So that is the court significantly erred. And from a layman's point of view, I'm not trying to make any big legal argument. I'm saying if somebody hold a gun to your head and say, give me that can't be consent. That's all I'm saying. I don't think it's an unreasonable position to maintain.
Good interview, Jade.
Thanks.
I think we need to delve a little bit deeper in the implications and whether or not we're striking the right balance. Because you and I had a conversation recently, and you were telling me about another conversation you had with another attorney to indicate that once you take up a job in public service, you know that this is what is coming at you.
Yes.
And therefore, if you can't give that consent, you shouldn't take up the job. And I don't agree with that position, because I think any other similar law could be made. For example, we're operating a global environment. You hear this thing talking about politically exposed persons that could very well have implications for you and I, who are employed to a charitable organization. How comfortable are you with that broad consent being given to third parties that shall comply, shall cooperate,
yes,
as Section 7 says? So I think we have to be careful and strike the right balance. But as I have the conversation in my own head, talking, Michael, what do you think? I also say, how do we do robust anti-corruption efforts? To be fair to Attorney Cameron, he said it. Go and seek a court order.
Yes.
So are we striking the right balance in a democratic society? Is the conversation we need to have as we fight corruption, but we maintain the right to privacy. And you and I were having the conversation that we also have to be careful here at JFJ. Sometimes we're out there and we're fighting for right to privacy. Government ought not to retain fingerprints for citizens who are detained under state of public emergency because you have a right to privacy. Are we fighting on principle when it comes to public officials, in particular the parliamentarians, who more often than not, the public perceive them to be, involved in some corrupt act? Are we using principle? So for example, Jade, if police bring me in and ask me some question and I feel kind enough to give the police some answers, the police have the right to go and verify by going to a banking institution without a court a warrant or some court order?
Well, certainly not, because the basis on which they could verify is that they are investigating you.
So shouldn't that threshold be similarly applied? Because remember now, Section 7, it's speaking generally to the Integrity Commission, including the Director of Information and Complaints.
Right.
Should the threshold be shifted to the Director of Investigation, which is under Section 50-something, and therefore it has to be when you are being investigated? But the next question is, anybody can tell any lie upon them statutory declaration,
right?
And you can't prove it.
I think one of the challenges is that even as we have been looking at our anti-corruption framework since 2022, reviewing the acts in Parliament and all of that, is that we have created legislative frameworks to mitigate what we saw as the cultural and social environment that we were in. That, there is especially at the time this act would have been passed or even considered, that there would have been a high chance of there being hidden assets that needed a robust mechanism to investigate, right? So, similar to the reasoning of the judge, I can see how the court could have come to the conclusion it came to. But I think one of the things Mr. Cameron said, and a clip that we didn't have time to play, it was that one of the challenges that he had was that the court was not given any direct evidence as to the prevalence of corruption in the country, as to
perception very high of it.
Yeah, perception versus actual prevalence, right? And because part of the reasoning relied on the effect of the corruption, he felt as though there was a need for that additional information about prevalence to have
One
underscore
could argue
the reasoning.
that we would not be having that because the rate of prosecution of corruption matters is very low, because there weren't robust laws to begin with. So it's a catch-22, and we have to strike the right balance. I'm not sure if an election year is the right year at this point. And given the judicial review that we expect based on the Prime Minister's application.
Yes.
Whether or not it's the right year to be going through this, because I'm not sure if we're going to be having balanced conversation, even from some of our civil society colleagues,
yes,
on this particular matter. But we will continue our discussion on it. Yeah,
most certainly.
So who won this trivia?
News commentator is back on top.
Long time. Section 16.
Section 16, yes. So Section 16 of our Constitution, Charter of Fundamental Rights and Freedoms, details, so it gives you all of the little things that are associated with your right to due process, including your right to having an attorney, to not having self-incrimination, to not have double jeopardy.
Like what is in the Ashley Judd movie, Double Jeopardy.
Yes. So all of those things are contained in that Section 16. So thanks for participating in the trivia, and News Commentator will reach out to you as usual with the prize. And thank you so much for joining us. I'm Jade Williams.
And I'm Michael Jackson. Have yourselves a beautiful and wonderful week.
Jamaicans, for justice, the people's champion. Justice for all, justice under the law, justice, Jamaica demand, right to life, right to liberty. Out of many we are one in a Jamaica, make it a better place for the boys and girls, created equal by the creator, for equal rights and opportunities, no to unlawful detention, and police brutalization, class, gender, race or religion, we not tolerate discrimination.
To join the fight against injustice, contact us at 755-4524 or JamaicансForJustice.org.
The people's champion.
Calling all businesses. Nationwide 90 FM's Back to School Fair is heading to Harmony Beach Park, Montego Bay on Saturday, July 26th, and your brand should be there. With families from St. James, Hanover, Westmoreland, Trelawney, and St. Elizabeth expected to attend, it's the perfect chance to connect directly with back-to-school shoppers.